Tractate Kesubos discusses the laws of the marriage contract, referred to as a Kesubo, and also the general obligations of the marriage agreement. Chapter 1 will begin discussing some points on the general laws of marriage. The first Mishnah says, "It's instituted that a virgin marries on a Wednesday, while a widow marries on a Thursday." This is because courts were in session on Mondays and Thursdays back in those days, and if somebody wanted to go to court after a marriage to dispute the claim of his wife's virginity, he'd be able to go the next morning. The Gemara says, she's married on a Wednesday, not a Sunday, which is discussed. It explains that we want to give 3 days for the husband to prepare for the marriage feast, Sunday, Monday, and Tuesday, and also the husband is only obligated to provide her with food by Wednesday. There's debate if, based on this, the wedding was delayed, if the husband is obligated to provide her food at this time. It's explained based on a different discussion that if the wedding was unavoidably delayed, the husband is not obligated to provide her food, while if it was voluntarily delayed by the husband, he would be obligated. Some also add that this notion of unavoidable delay would not affect a divorce document. It's debated what the source for this is. A number of options are suggested and all rejected, and it's explained that it's just a logical conclusion. Essentially, it could either be that this notion of the impermissibility of delaying bringing a divorce document could either be a situation of a modest woman, so the husband just decides to delay here voluntarily, and she'll assume it was involuntarily and then just wait, unable to remarry. Or alternatively, it could be an immodest bold woman where the husband is actually unavoidably delayed, but she assumes he's just stalling voluntarily, so she'll remarry impermissibly and father illegitimate children. So because of this, it's deemed that there's no notion of delaying a divorce document. The permissibility of the court to enforce such a document is that as they're allowed to betroth a woman, they can also retroactively remove a betrothal, whether it was done with money or through cohabitation, in which case they could just retroactively rule that it was an illicit cohabitation, thereby nullifying the entire marriage. Others say it's actually the exact inverse of all of this, that we do apply the principle of an unavoidable circumstance delaying a divorce document. Again, various sources are suggested and debated. Anyways, we said earlier that marriages tend to be on Wednesdays. This was instituted after the enactment that courts would convene on Mondays and Thursdays. Before that, people would just marry whenever. And they could also still do that now if the court also convenes whenever, obviously assuming you took care of the wedding preparations before Shabbos. This is discussed at some times. It became dangerous to marry on Wednesday as it was instituted at some point in this time historically that anybody married on a Wednesday had to go to the local governor and cohabit with them first, and many modest women would treat this as a life-threatening matter, among other issues. So anyways, people started marrying on Tuesday, which was fine, but to marry on Monday was only done due to an unavoidable circumstance, such as a general and an army coming to town during the week and a while after, and there's a worry they'll cause issues with the wedding if it's done any later than this date. Alternatively, the unavoidable circumstance is the sudden death of a relative while they're finishing the wedding preparations, so they can just marry earlier, have the wedding, and then do the burial without delaying it. This applies if it's the father of the groom that passed, or the mother of the bride, as if they delay the wedding then no one will re-prepare it. It further says that the wedding must have been prepared to the point where the food has all been prepared, as if it could just be resold and rebought later. They can just delay the wedding until afterwards. We bring sources. It clarifies some further laws in regards to a mourner getting married. We also say that in the event that a marriage occurs towards the end of the week, you shouldn't cohabit with your wife for the first time on a Friday night, as you could cause bleeding, creating a wound of a sort, and you can't create a wound on Shabbos. And it also shouldn't be done on the night after Shabbos, and there's debate why that's not allowed then exactly. There are a few suggestions. It said to be impermissible out of concern that he might slaughter a bird to prepare as a wedding meal after Shabbos ends, which would also be an issue for cohabiting on a Friday night. There's also debate generally as to when the act of cohabitation takes place by marriage. By a Wednesday, it said that by marrying a widow, it's done on Friday, either as there's blessings there, or so that way we make the husband spend time with his wife for the next 3 days, Thursday, Friday, and Shabbos. There are some practical differences, either if the man doesn't work or a holiday fell out on a Friday, where we know he'll be spending time with his wife either way. It cites some related verses on this as a side point. It says your fingers are shaped in a point based on a verse, so you can plug your ears if you hear someone saying something improper, like gossip, for instance, which is a very negative thing to listen to, which is also why you have earlobes. Anyways, it further debates if cohabiting for the first time with someone legally constitutes as the creation of a wound, which would make such an act for the first time impermissible on a Shabbos, depending on what type of blood you hold that wound creates, and whether or not this is considered to be a destructive or a constructive act. There are several opinions who disagree on this matter. We cite a number of sources which seem to imply that it would be permissible to do such a thing. There are several different opinions listed ruling as to whether it is or is not permissible. The final ruling is that it is permissible to cohabit with a woman for the very first time on a Shabbos. It also speaks on some of the blessings said by a wedding. These are further discussed. There are 7 blessings called the Sheva Brachos said in the house of the groom, although in Judea they would sometimes say it in the house where they did a rusin, the final stages of marriage. It also lists the text of the blessings. It says they're said before 10 people, all 7 days of rejoicing, although others say only when new people come to the meal, and it further lists all the text of these blessings. These and further variations as to how the blessings were read are discussed further. There are some particular related incidents mentioned, and further phrasing on other blessings, like by a mourner and similar. By the Sheva Brachos of a wedding, there are also several cups of wine that are drunk before eating, during eating, after eating, by the after blessing, and others, which were instituted, one of which is drunk in honor of the sage Rabban Gamliel, who set the practice, starting with himself when he passed, that he should be buried in very cheap garments to allow burial to be easier on poor people, as not everybody also used cheap clothing. Anyways, in regards to actual testimony that somebody would make that the wife he married was not actually a virgin, we believe him, and they can no longer be together. This is clarified to apply either if he's a Cohen, meaning she'd be forbidden to him even if she was violated anyways, or it was a case where a father accepted betrothal on his minor daughter under 3 years and a day old to eventually one day have this marriage go through when she becomes an adult, when she's actually legally allowed to marry, in which case the cohabitation must have occurred way later after this, as you're not allowed to cohabit with somebody that young. This case is further discussed. There's debate if this is a valid ruling based on other sources. Some also say in such a situation she doesn't get her marriage contract, although this is similarly debated if it requires actual evidence of an absence of blood or not. It also disputes if the notion of a Kesubos, the marriage contract, is of biblical origin or not. It also cites some specific cases of people who came to sages claiming their wives were not actually virgins when they married. One was actually admonished for this, as the only way he could have been an expert in such things was if he was frequenting harlots, and the other was said that perhaps his act of cohabitation was done at a slight angle, so it didn't appear to him like she was a virgin. There was another incident where a couple came before a sage, one saying she hadn't bled, the other saying she was a virgin, so he soaked the sheets in water and found some blood. There are several other similar incidents mentioned. New Mishnah. The Kesubos, the document given at the start of a marriage, contains the stipulation for an agreed-upon sum of money to be given to the wife upon the termination of the marriage, either through divorce or widowship. For a virgin, it was typically in those days done at a minimum of 200 zuz, which was an old form of coin, and for a widow was lower than that, 100. A virgin who was widowed, divorced, or had done chalitza while in erusin, the final stages of marriage, her kesubos is still the full 200 zuz, although the husband can make a claim against her if he finds she's not a virgin. The Gemara cites a few verses which source some of this terminology. It also speaks a bit on the health benefits of dates, and some other points on etymology. New Mishnah. A convert, a captive, and slave girl, if they were a child under 3 years and a day when they were ransomed, converted, or emancipated, eventually, when they get older and marry, their Kesubos dowry is still the full 200 zuz for that of a virgin, although a claim could be made against them. The Gemara debates if a minor is allowed to be converted by a court. If a minor had been converted, there's discussion on if she needs to reconvert when she becomes an adult. New Mishnah. In the event, God forbid, that somebody had cohabited with a minor girl, or in the case that a minor boy had cohabited with an adult female, or if a woman became no longer physically a virgin by an injury from a piece of wood or something, their Kesubos, when they eventually do marry, is still the full 200 zuz as if they were still a virgin, meaning they are not held responsible for any of these events occurring to them. Some say by the injury, however, it is actually reduced to 100. A virgin widow, divorcee, or somebody who had done chalitza from nisuin, the first stage of marriage, their Kesubos dowry is 100 zuz, and they can't have a claim made against their virginity. A convert, captive, or slave woman who were ransomed, converted, or emancipated when they were older than a child, meaning over 3 years and a day, when they eventually get married, their Kesubos dowry is 100 zuz, and they can't have a claim made against their virginity. The Gemara says, as a minor boy cannot legally cohabit with anybody in a circumstance where he had, it's considered the same as if the woman was injured by a piece of wood, and she has her dowry paid in full, according to some. Similarly, if, God forbid, a man had cohabited with a minor girl, that does no damage to her dowry when she eventually grows up, and she'll still be given the full 200 zuz when she one day gets married, as she's not in any way held responsible for that thing which occurred to her earlier on in her life. These points are for the discussion. There's debate based on this if the standard amount given to a woman who was said to be a virgin and was then found to not be one is only 100 zuz. Some say it's actually nothing. This was just unique, as the woman in question was already married before, so the husband should have at least suspected she was no longer a virgin. There's variation on this discussion, which is qualified. New Mishnah: if somebody eats in his father-in-law's house in Judea without witnesses that he didn't seclude himself with his betrothed, he cannot make a claim against her virginity after they marry, as they would typically have secluded themselves. The Gemara says that even within Judea, there was some variation between customs in different places, and this is discussed. New Mishnah: a widow, whether she's a Kohen or not, has a Kesuba dowry of 100 zuz. The Kohanim would typically give 400 zuz as a Kesuba if their wife was a virgin, which was permitted. The Gemara says for Kohanim, by widows, it was initially 100 zuz, but then people started treating the marriages lightly, so they raised it to 200, but then people stopped marrying widows, so they brought it back down to 100. It also says an eminent family, not just Kohanim, could set the contract to 400 zuz. New Mishnah: if somebody marries a woman and finds she's not a virgin, but she says, I was actually violated by somebody after you betrothed me, so it shouldn't affect the contract, while he claims it occurred before the betrothal, there's a debate as to who we believe. The Gemara says generally if somebody says to a person that you owe me money, and the person says, I don't know, there's a debate if he needs to pay it. Some say he does, that's a definite argument against an uncertain one. Others say he doesn't need to pay it, as the money should stay with who currently has it. Anyways, it suggests that possibly that's the same logic as the arguments by this case. Some say no, as there's a principle known as migoy by the case of the betrothal, which essentially states that as she had a much better claim, which wouldn't have been able to be disputed at all, like that she lost her virginity from an injury, for instance. So there's an additional reason to believe the woman by that case, as she chose to not make a much better and easier believed argument, while such a thing doesn't apply by the situation where somebody claims that the other person owes them money, as no such principle applies there in that situation. We say we follow the opinion that a definite statement doesn't override an unsure one. However, by our Mishnah, due to the difference between the cases and the additional reason to believe the woman that was described, we do believe her. New Mishnah: if a woman says she was no longer a virgin from an injury, and the husband says it was from a prior person, actually, it's debated who we believe. Some say the woman, some say only if she brings proof. The Gemara debates if the situation is where it's between paying 200 zuz and 100, or 100 and nothing, based on what you hold the payments are. It also lists the case in addition to the prior, to teach the extent of the differing opinions. The first says she's not believed in spite of the migoy claim. The second, which says she's believed in spite of the lack of a migoy claim. New Mishnah: if the court saw a woman speaking to somebody and they ask what his status is to see if it'd affect her marriageability, and she says he's a Kohen, meaning not an illegitimate person, there's a debate if she's believed or if she needs proof. Similarly, if a woman is pregnant and she says the father was a Kohen and not somebody illegitimate, some say she's believed, some say she needs proof of this. The Gemara says that when it says that she was speaking to somebody, that either means that they were in seclusion or it's just a euphemism for cohabitation. This is for the discussed. The logic of these cases is for the qualified. It also debates if such a woman's daughter is considered legitimate or not. It's debated as to who we hold like, and further discussed. It's additionally debated. New Mishnah: there was an incident recorded where a girl was violated by a man from a town. It was ruled that if majority of the members of the town were fit to have their children marry a Kohen, this girl's child should be allowed to marry a Kohen legally. The Gemara further discusses this. There are further points on different majorities that create a presumption that a child is eventually allowed to marry a Kohen, and there are some particular instances discussed and some additional qualification on these laws. And that's the end of chapter 1.